Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Robert E. Temmerman Jr., henceforth known as Bob. Anyway, Bob Temmerman is an attorney specializing in estate planning, incapacity planning, and estate and trust administration. And his firm also does estate litigation here in San Jose. He's a partner and founder of the firm called Temmerman, Silly, and Coleman, LLP. Bob received a BA in economics and political science, magna cum laude from Boston College.
Correct.
1975, and his Juris Doctor, magna cum laude from Santa Clara University in 1980. He's an active speaker in our local community here, and I guess in other parts of the country, about estate planning and estate administration. Just recently we had the Jerry Kasner Estate Planning Symposium with Santa Clara University here locally, and Bob made a presentation. He also has talked for our estate planning councils and bar associations, and he's contributed chapters to books including California Estate Planning, which is published by the Continuing Education of the Bar. And he's also participated in writing actually the rules of the court here for our Santa Clara County Probate Court. On a personal note, Bob is quite an athlete, and he just participated in a 2-month bike hike across the United States, which I think is awesome. And he plays amateur hockey and lots of other sports activities. So Bob and I are going to be talking about this topic. I'm an executor. Now what? And before we get started, I want to caution our viewers that this is just an introduction to this. Bob has spent years studying this stuff. We want you to consult with an attorney, especially when administering an estate. This is a huge topic. We can only cover some highlights. We're discussing rules for administering estates in California. Bob's a California attorney. I'm a California CPA. The laws are different in other states, so be aware of that as well. Pretty good introduction there, Bob?
I think you hit all the high points, Mike.
Good. Thank you. Thank you so much for joining me today.
My pleasure.
It's
good to see you.
Thank you. It's a real pleasure having you as my guest. Okay, Bob, well, let's just sort of get into this thing. So let's start off. What is probate?
Mike, probate is the process upon which an estate is administered in a post-death context. So when an individual dies, and they die either without a will or with a will, the court will take supervision of the estate, appoint an executor or appoint an administrator, the person in charge, who was then guided to administer that estate and bring it to a close. So it's, in essence, it's a court-supervised process. There are some rules and restrictions that govern probates that don't necessarily govern alternative methods of transferring property. And it is a process that takes 9 months, 6 months to 9 months on average, sometimes a little bit longer.
Okay, thank you. Now, do all estates have to go through probate?
No, in fact, most estates do not go through probate. For clients that are properly planned, most of those planned estates are designed to avoid probate because, quite honestly, probate is a time-consuming process and it's a fairly expensive process. So you don't want to opt into probate necessarily. You want to try to avoid it. There are many assets that do not transfer through probate. A good example would be a life insurance policy. The vast majority of life insurance is paid to a designated beneficiary that you've named on your life insurance policy. So assets such as life insurance or retirement plans typically are not part of a probate estate. It's those assets that are titled just in the name of the decedent that typically have to go through probate, and only if they exceed a certain sum of money. Right now that amount is $100,000 in California. So if the totality of assets in the decedent's estate exceeds $100,000, then we have to open a probate.
Okay. Now, if the decedent had a living trust, does that automatically mean that no probate is required?
No, and that's an unfortunate mistake that many clients and others that plan with the use of living trusts make. A living trust is designed to avoid probate, but it's only effective, Mike, if you have actually taken the time and effort to transfer assets into the name of the trustee. For most clients, when they create a trust and they self-trustee the trust, meaning that they're going to name themselves as the persons in charge of their own trust. In order to be effective, you need to transfer your assets into it. A common example would be to take your home and make sure that that asset has had a new deed that goes from your name individually to your name as trustee. California case law has developed to allow us, in certain cases where the intent of the settlor, the person who created the trust, is manifest in some fashion, to allow us to try and avoid probate in a post-death context by filing a petition with the court, sometimes called a Hegstead petition.
Right. So this is like one example of that would be is if you made a schedule that you attached to your trust where you listed assets, but you may not have actually changed the title on them.
That would certainly help. I mean, the idea what the court's looking for when the asset is not titled in the trust is what was the decedent's intentions? Mm-hmm. And you can have all sorts of declarations by the drafting attorney and by the surviving spouse or a family member, but if there's a conflict as to where the asset would go, mm-hmm. under a will it might go to A, but under the trust it goes to B. Right. You can see ferreting out intention can be a difficult issue for the court to face. Yeah. In the vast majority of cases, there isn't a conflict, and hence the court will approve those petitions. But the lesson to be learned is if you're going to use a trust, make sure you fund it. Otherwise, it's only a partially completed project, and it's going to require some effort in a post-death context. And most of my clients want to make sure they make it as easy as possible on their family members.
Right. Okay. A husband who had a will dies. He leaves all of his estate to his wife, and all of their property was community property. Is a probate required in that context?
And the answer to that question is no. Under California law, we have some expeditious mechanics for transferring property to a surviving spouse. If the will leaves everything to my spouse, we can file a very simple spousal property petition post-death without opening up a formal probate. We're in court, but this time we're just in for a one-stop. Ask the court to confirm that the decedent's half and the surviving spouse's half all belongs to the surviving spouse. And if we do that, it's just once into court, once out, you have your order, the surviving spouse now owns everything. If, on the other hand, the decedent's will left it somewhere other than to the surviving spouse, then we would have to open a probate.
Okay. What is community property, and why is that status important for estate administration?
Community property is property that's owned by a husband and wife. It's acquired during marriage, generally under California law, as a result of one's time, labor, effort, skill. What does that translate mean? It's what you earn, what you acquire with those earnings, such as a house purchased during marriage as a result of one's employment. Mm-hmm. The importance of community property is in two circumstances: divorce, where community assets are divided equally, and in death, where the decedent can only dispose of his or her one-half interest in the community.
Mm-hmm. Okay.